All right, let's jump right into this explainer. We are zeroing in on the ACCA Corporate and Business Law exam, specifically how a company gets its hands on cash and, crucially, how it protects it. This is an absolute core pillar of the syllabus. Understanding the legal boundaries of corporate finance is absolutely essential, not just for crushing your exam, but for really grasping how real-world businesses operate out there.
So, think about it. How does a business actually fund its day-to-day operations? And more importantly for you, what are the massive legal traps waiting if things go sideways? Basically, companies have two main routes. They can either sell off a piece of themselves, which we call equity, or they can borrow money from a lender, which is debt. But listen, the law treats these two avenues very, very differently.
Here is our roadmap board today. We'll start with raising funds through share capital, then look at the strict rules of capital maintenance, move on to borrowing money via loan capital, compare fixed and floating charges, and finally, tackle the infamous 21-day registration rule.
Kicking things off with Part 1, Raising Funds Through Share Capital.
It's actually kind of fascinating how this boils down to a strict binary choice. Look, ordinary shares, they give you the voting control. You are essentially the boss. But with that power comes the risk. Your dividend fluctuates, and if the company ever winds up, you only get whatever residual capital is left sitting at the very end of the line. Preference shares, on the other hand, well, they let you skip that line. They don't typically get a vote, but they do get a fixed dividend priority, meaning they get paid their fixed percentage before the ordinary shareholders see a single penny.
Now, as we navigate all this, getting the terminology right is absolutely crucial. Don't let the examiner trip you up here. It's a simple four-step breakdown. Authorized is the absolute maximum a company can issue. Actually, scratch that. It's largely obsolete nowadays, but still really good to know for context. Issued is what has actually been handed out to shareholders. Called up is the amount the company has formally knocked on the door and asked the shareholders to pay. And finally, paid up, that's the cold, hard cash that has actually landed in the company's bank account.
So if you remember just one thing, make it this golden nugget. Ordinary means risk and reward, while preferences is all about that fixed dividend priority. Seriously, lock that into your memory bank for exam day.
Moving right along to Section 2, the Rules of Capital Maintenance.
Okay, so it turns out if you issue shares for more than their basic nominal value, say the nominal value is just £1, but you manage to sell it to an investor for £5, well, that extra £4 goes straight into what's called a share premium account. The law is incredibly strict here. It dictates that this is a non-distributable reserve. You absolutely cannot just pay it back out to the shareholders as a standard dividend. No way. It is completely locked in.
You might be wondering, why is the law so incredibly rigid about this? Well, it's because limited liability protects the shareholders. If the whole thing goes under, shareholders only lose what they put in. Their personal houses and cars are perfectly safe. Because of that safety net, the company can only return capital in three extremely specific, legally regulated ways. A formal reduction of capital, which usually needs the court's blessing, a purchase of its own shares paid strictly out of distributable profits, or the redemption of shares. These massive hurdles are there to ensure the cash isn't just quietly drained out the back door, leaving creditors totally empty-handed.
And this leads us to a huge realization, literally a light bulb moment. The entire concept of capital maintenance, it exists purely to protect the company's creditors. It makes sure there's an actual solid pool of funds available to pay off the people the company owes money to.
Okay, let's pivot to Section 3, borrowing money, or loan capital.
So what happens if selling shares just isn't cutting it and the firm really needs to bring in some external cash? The legal fix here is the debenture. Now, don't let that fancy corporate word intimidate you. In corporate law, a debenture is just a formal, written acknowledgement that the company owes a lender money. That's it. It's simply the document that officially creates or acknowledges the debt.
Now, lenders, they aren't stupid. If a bank is going to hand over millions of pounds, they're definitely going to demand some security just in case the business goes belly up. This effectively splits lenders into two very different camps. You've got secured debentures, where the lender gets a strict legal claim over specific company assets, and then you have unsecured debentures, who literally have no claim on specific assets. They just have to cross their fingers and desperately hope the company can pay them back.
Which brings us to Section 4, fixed versus floating charges.
The contrast here is pretty striking, and it's a huge favorite for the examiners. A fixed charge completely locks down a specific, highly identifiable asset. Think a factory building or a massive piece of machinery. The catch? The company literally cannot sell or dispose of that asset without getting the lender's direct, explicit consent. On the flip side, a floating charge hovers like a cloud over a changing class of assets. Think inventory or raw materials.
The business can just keep selling its stock and buying new stock in the ordinary course of business without having to call up the bank for permission every single time. It's one more flexible.
But here's the rub. That beautiful, breezy flexibility of a floating charge, it vanishes in a heartbeat the moment the company defaults on its loan, or worse, goes into winding up. This triggers a major legal event called crystallization. Imagine that hovering cloud suddenly dropping down and freezing completely solid. The floating charge converts directly into a fixed charge, and all those changing assets are suddenly locked firmly in place for the lender to seize.
This single distinction is a total game changer. Fixed equals a specific asset, floating equals a class of assets that crystallizes on default. Recognizing exactly when an asset crystallizes is a guaranteed way to score marks when analyzing insolvency scenarios in your exam. Finally, we hit Section 5, the 21-day registration rule.
21. That is the magic number. 21 days is the strict, totally unforgiving legal deadline to register these charges at Companies House right after they're created.
If a lender, or the company for that matter, misses this 21-day window by even a single day, literally just one day, the fallout is devastating. First off, their carefully negotiated security becomes completely void against a liquidator, an administrator, or other creditors. It is exactly as if the security never even existed in an insolvency situation. Poof, gone. Second, as a direct punishment, the underlying loan amount becomes immediately repayable by the company.
The reason getting that registration sorted is so absolutely critical comes down to the insolvency payout waterfall. Think of it like a line at a buffet when the food's running out. When a company dies, the properly registered fixed charge holders eat first. They swoop in and take the assets secured to them. Next in line are the registered floating charge holders. Finally, way down at the bottom, the unsecured creditors are left to fight over whatever tiny scraps remain. If you forgot to register your fixed charge within those 21 days, you lose your VIP status at the top and plummet all the way to the bottom to join the unsecured creditors.
So the core lesson here is completely black and white. Register your charge within 21 days, or it is void in insolvency, period. It is without a doubt one of the most strictly enforced rules you'll find in corporate and business law.
As we wrap up this explainer, you really have to ask yourself, if missing a strict 21-day deadline causes a multi-million-pound security to just vanish into thin air during insolvency, can you really afford to forget the rules of funding the firm? Keeping this clear framework of equity, capital maintenance, secured debt, and that brutal 21-day rule in your head makes navigating corporate law so much easier. Take these concepts, apply this logic directly to your exam scenarios, and you are going to navigate the legalities of funding the firm absolutely perfectly.